and welcome back to Sessions with an Adoption Attorney. This is session number 4, or episode number 4, and today we will be dealing with the rights of unmarried birth fathers when it concerns adoption in New York. Thanks for listening. Before we begin, I just want to thank our sponsor once again. That's BlueSharkStraps.com. BlueSharkStraps.com sells premium leather, nylon, and silicone watch bands for a fraction of the cost of products sold by the large luxury watch manufacturers. You can use code ZURICALAW for 25% off your order. That's ZURICALAW. And you could purchase your straps at BlueSharkStraps.com. That's BlueSharkStraps.com. Before we start the actual cast, just wanted to give another brief introduction. My name is Anthony Zarica. I am the host of your podcast, and I am an adoption attorney here in New York City. I went to law school down in Tribeca at New York Law School. I was born and raised in Staten Island, New York, and my office is currently in Midtown Manhattan. I really enjoy what I do in terms of adoption law, helping both families and children. And I look forward to helping you guys with this cast answer some of the questions that you have about adoption law. Now, you could reach me on the web at www.nycadoptionlawyer.com, on Twitter at nycadoptionlaw, or on Instagram at nycadoptionlawyer. Any of the links I mentioned just now or in the future on the cast will be found below in the description, and please go check those links out at your own leisure. Getting started on the cast, we are talking about the rights of unmarried birth fathers in New York. Other states may have their own set of laws and guidelines to follow when it comes to unmarried birth fathers, but we will be dealing only with New York law today. This is going to be a pretty brief cast, just going to discuss a couple of things about it, and if you guys have any questions, again, you could reach me below or in any of the links provided. So in New York, unmarried birth fathers fall into two different categories. One is what's called a notice father, and one is called a consent father. A notice father has no right to stop an adoption. A notice father just has the right to be notified or put on notice that the adoption is taking place, and then he has the rights to try to persuade the judge that the adoption might not be the best interest in the child, but ultimately he cannot say no to the adoption legally. Consent father, on the other hand, actually has the right to veto or say no to the adoption. In both instances, there is a set of categories that one must fall into before they're considered either a notice father or a consent father, and we're going to talk about those categories right now. In order to be considered a notice father in New York, there are 7 different categories that an unmarried birth father can fall into. One is that he's filed an acknowledgement of paternity. 2, that he's married to the birth mother within 6 months after the child's birth, but prior to her signing of consent or surrender. 3 is that he's identified as the father by the biological mother in a written sworn statement. 4, he's actually living with the child and the child's mother and is holding himself out to be the father. 5, he's recorded on the birth certificate as the father. 6, he's filed a notice of intent to claim paternity. Or 7, he's actually been adjudicated as the father by a court. So the unwed birth father must fit into one of those 7 categories to be considered a notice father. And again, remember, notice means he just needs to be put on notice. He cannot legally say no to the adoption. Now, switching gears to the flip side of that is a consent father, where the father has more rights. He actually needs to give his consent to this adoption. Now, when we talk about consent fathers, there's actually 2 specific set of circumstances we like to discuss. And one is when the child is less than 6 months of age, and one is when the child is older than 6 months of age. We'll deal with the older than 6 months of age first. Basically, when the child is older than 6 months of age, this usually falls under a step-parent adoption, where a step-parent comes into the picture, wants to adopt the child, and now we have to see if the unmarried birth father has any rights to consent to this adoption. So if the child is older than 6 months, 6 months after birth, then the father is a consent father if the 2 of these first statements happen or the third statement. So again, I'll explain that a little bit when we go through it, but 2 of the first statements must be together or the third statement. So one, he paid a reasonable and fair sum in accordance with his means for child support. And two, he visited the child at least monthly or maintained contact at least monthly when physically and financially able and not prevented from doing so by the custodian of the child. Or, the third statement, he openly lived with the child for 6 months during the year before the child was placed and held himself out to be the father. So we have the two first statements with an and then we have the third statement or those first two statements. So again, those first two must be together, or the last one where he openly lived with the child for 6 months, that could be on its own. If any of those requirements are met, he's considered a consent father and he has to give his consent to the adoption. Now this is if the child is older than 6 months after birth. If the child is less than 6 months after birth, then the father is a consent father if the following. He evinced a commitment to the child by holding himself out to be the father, or he's offered to pay a reasonable sum for birth expenses and her child support. He demonstrated an ability and a willingness to assume personal custodial responsibility for the child, and he takes prompt action within the first 6 months of the child's placement to attempt to establish a parental relationship with the child. This could be just making plans for the baby, seeking legal advice, filing a petition with the court. Just because he opposes the mother's plan doesn't necessarily mean that he has his own plan for the child. So that is how the father needs to be a consent father if the child is less than 6 months after his birth. Now, if the unmarried birth father doesn't fit into any of these two categories, then he's considered a no-rights father. However, just because he's considered a no-rights father doesn't necessarily mean that he doesn't need to give notice of consent. The court still should determine whether he should be given notice or consent. So ultimately, there's still, a little gray area in terms of what the unmarried birth father's rights are, but it's always best to leave it up to the court to determine whether he should be a notice father or a consent father. Again, thanks for listening, guys. If you have any questions, again, reach out to me at the links below. Next week, we're going to, actually in 2 weeks, we're going to try to do a little different topic for the cast. I'm going to try to take some listener emails. I'm going to answer those emails. Hopefully, we're going to get 5 to 10 emails going for the cast next week, so please send those if you guys have any questions. And once again, thanks for listening. I hope you guys learned a little bit today, and if you have any comments, please leave them below. Have a great day, guys. Bye bye.